Hello, everybody. Nice to see you. It's a beautiful day today here in Great Neck. I wanted to say hi and share with you some great information. So let's get right to it. Your records are missing. Specifically, your original records are missing. Now, what does this have to do with anything? Well, it has a lot to do if you intend on bringing a medical malpractice case against your treating doctor. So let's talk about the scenario here. So now, here's the scenario. You think that your doctor was careless, and you think that his carelessness was a cause of your injury, and you think that your injuries are significant and permanent. And now, what do? You decide that you want to go to a second doctor. And now, when you go to the second doctor, he says, hey, where are the records from the first doctor so I can see exactly what it was that was done? So you go back to the first doctor and you say, hey, can I get a copy of my records? They say, no problem. So you get a copy of your records. Now what? Okay, now you get that copy, you paid for that copy, now you take it over to doctor number two. Now doctor number two has the ability to go through and see exactly what was done by doctor number one. Excuse me. Okay, everything's fine, right? Well, not exactly, because now doctor number two has to try and fix what doctor number one did. And you get the sense that doctor number one was careless. You get the sense that he deviated or you get the sense that he violated the basic standards of medical care. And now you are curious. You talk to an attorney and you say, listen, I think I have a valid case. So now what happens? So now your attorney will go ahead and try and get copies of the doctor's medical records. Why? Because a requirement here in New York to see whether or not you have a valid case is to go ahead and obtain all of your medical records and then have them reviewed by a medical expert to determine whether or not, number one, the doctor was careless. Number two, whether his carelessness was a cause of your injury. It doesn't have to be the cause. And number three, whether your injuries are significant or permanent. It's a beautiful day today. Okay, so those are the three things that are needed in order to go ahead and confirm that you have a valid case. Now, your attorney obtains a copy of your original records from doctor number one. Your doctor number two has obtained a copy of your original records because you, the injured patient, went and got a copy from the doctor's office and physically brought them to doctor number two. Okay? So what happens then? What happens next is now your expert, your medical expert, or I should say the attorney's medical expert, has confirmed that in fact you do have a valid basis for a case. So what does that mean? It means that you are now permitted to go forward with a lawsuit against your treating doctor. I shouldn't say treating, against the doctor whom you first treated with. Excuse me. Let's try and get some water here. Okay, so we know that the title of this video is called Your Original Records Are Missing. There we go. Just move that headline down a little bit. Terrific. Okay, so now here we are. You have enough information to go ahead and start your lawsuit. So what happens next? What happens next is that now your lawsuit actually gets started. Your attorney files papers in order to start the lawsuit. And those papers are known as a summons and a complaint. Those are the allegations that we actually go ahead and deliver to the doctor and his attorney and say, listen, you did something improperly. And as a result of that, this patient suffered significant harm and injury. Now, the doctor and his attorney have a certain amount of time in which to answer those allegations. And you know, in law, what we call that? We call that an answer. And here are the typical defenses that we usually see in these types of cases. Number one, the doctor says, why are you suing me? I did absolutely nothing wrong. That's defense number one. Number two is, if I did something wrong, whatever I did not cause or contribute to your injuries. That's defense number two. Number three is, they turn around and say, you know what? If I did something wrong, so did you, Mr. Patient. How do you like that one? Then they turn around and say, you know what? If we did something wrong, and whatever I did caused or contributed to your injuries, guess what? Your injuries really are not as bad as you claim them to be. That's the fourth typical defense that we see in these medical malpractice cases. And, oh man, got a tickle. Excuse me. Okay, so what happens then? Well, at the first court conference, to schedule exactly when things will happen during the course of your case, your attorney and defense attorney will meet up and now agree on a schedule about when things will happen. And you know what's interesting? The defense attorney turns around and says, you know what? We are never, ever going to negotiate or settle this case. And your lawyer says, fine, we'll see you at trial. Okay, so what does that mean? That means that 2 or 3 years down the road, guess what? Now your case is going to trial. Because in New York, that's the typical length of time in which it takes to get through the discovery process. Hey, Tim, nice to see you. Thanks for the thumbs up. That's the typical length of time in which it takes to get your case to actually go to trial. Fine. So now let's say you've gone through the entire litigation process. It's now 2 or 3 years down the road. Well, guess what? Your attorney now has to go ahead and get everything ready for trial. He has to prepare you. He has to... Oh, man, sorry about that. He has to prepare your case for trial. And he does that a number of different ways. Not only does he have to... Let me try this again. Not only does he have to prepare you for cross-examination, as well as the type of questions that he's going to be asking you, but he has to prepare his medical experts for trial as well. In addition, he has to go ahead and get all of his exhibits lined up. He has to prepare legal briefs to submit to the judge when you go into trial. And here's what leads us to the beginning title of this particular video. Your attorney has to go ahead and subpoena all of your medical records into court. Why? Because there has to be a chain of custody showing that the records went directly from the doctor's office into court. It wouldn't do any good if now we brought in a copy of the records that we say your doctor gave to us, and now we handed it to the jury, or we handed it to the judge saying, Judge, we'd like these marked as evidence. You want to know why? It's because the defense would argue that there's a chain of custody problem. He's going to argue, how do we know that those are in fact accurate records? How do we know that certain records weren't removed? How do we know that certain records weren't changed or altered? How do we know anything? Because, hey, why should I believe the plaintiff's attorney, the attorney who represents the injured patient? I mean, that's a somewhat valid argument. If there's no chain of custody, then the defense, my opponent, has no idea whether or not these records are accurate and factual and complete and thorough, right? So what do we typically do? We take a document called a subpoena. That allows us the opportunity to go ahead and compel a doctor or a hospital to go ahead and deliver your medical records to the courthouse. Now, there are a number of ways to do that, and I'm not going to go into the details about that now, but here's the point. Your attorney has to take a subpoena, which is a piece of paper that says you are now directed, you are compelled by law to go ahead and send a complete, thorough, accurate, and certified copy of those records and deliver them into court with a copy of the subpoena. Now, as an alternative, you can go ahead and deliver the original records into court. So, the doctor's office or the hospital can go ahead and deliver the original records or a certified copy of the originals. That's what I meant to say. All right, so what happens then? Well, here's what happens next. So now, most doctors' offices are going to go ahead and have a secretary or someone else go and get copies of the records, make copies, and then they have a piece of paper which certifies, yes, my name is Jane Jones, and now I certify that I am the record keeper for the doctor's office, and I have reviewed these records, and I have come to the conclusion that these are thorough and complete records, and I certify that they are accurate. They are an accurate copy, photocopy of the original records. And now that's a certification that goes on top of the records, together with the subpoena. Now they get sent into court, and now they're ready to go. So now when the trial gets started, we go ahead and get those subpoenaed medical records. Now we can use them to introduce at the time of trial, get them into evidence, and now all the different witnesses who testify can use those records that have been admitted into evidence. But here's the dilemma. What happens if, hey, Kevin, nice to see you. Thanks for joining me. Thanks for the thumbs up. What happens, though, if the doctor's office turns around and says, hey, we can't find your medical records. We don't know what happened to it. We have no clue. We have no idea. And you sit and wonder, how is that possible? Because you know that you obtained a copy of your own medical records and brought them to doctor number 2. You know that your lawyer, in order to evaluate whether or not you had a valid case, what did he do? He went ahead and got a copy of the medical records. So clearly, the doctor at that point had the original records. So now the question becomes, where did they go? Did they disappear on their own? Did they intentionally disappear? Is someone trying to hide them? Well, you may not know the answer and you may not get an answer. But here's what we do know. When your case goes to trial, if in fact the doctor's office claims that they can no longer find the original records, can you use the copies, the photocopied records, as originals in order to introduce them at trial so that all of the witnesses who are going to testify can now go ahead and testify based on those records? And the answer is, yes, we can. But we have to jump through certain hoops in order to make sure that what we are doing is accurate, what we are doing is correct. Now, why do I say that? I say that for a number of reasons, and it goes back to the authenticity of the records, going... Excuse me. And my coughing. Yeah, we don't want to do that. So let's take a quick water break. So what happens? We have to ensure that those records are in fact accurate. We have to ensure that they are complete and thorough. Now, how do we do that? We have to request a copy of those records from Dr. Number 2, right? And now we go ahead and compare it with the copies that we have. Then we have to notify our adversary, my opponent, the defense lawyer. Say, listen, Dr. Number 1's records, his originals, are missing. Could you do me a favor? I need to compare my copy with Dr. Number 2's records, and I'd like to compare your records as well. In all likelihood, the defense attorney will give me a copy of his records to make sure that everybody is on the same page, that we all have the same records. Likewise, I will exchange my copy and Dr. Number 2's copy with my opponent so that he can see also that all the records we have are the same ones that he has. Now, it's going to be a bit tricky if, in fact, some of those records are missing, whether they're from my copy, Dr. Number 2's copy, or the defense lawyer's copy, because now that throws a wrench into the mix. Why? Because now something's missing. And now fingers can be pointed any which way you want. Oh, the Dr. Number 2 took something out. He didn't want to implicate Dr. Number 1. Oh, the defense lawyer took something out. Or plaintiff's attorney took something. Whatever it is, if certain records are missing when we compare each of those copies, now there's going to be a big problem. But if we can show the court that there are no originals left, and the doctor has now certified and sworn an affidavit that he says, listen, we've turned our office upside down, and we cannot find it. We've searched and searched, and we cannot find it. In fact, we know that we provided copies to plaintiff's attorney, to the defense attorney, to Dr. Number 2, to the patient. Okay? In that instance, there's a good possibility that the judge will allow the photocopies to come in as evidence since we don't have the original records. So we really have to go ahead and get an explanation from the doctor, from the record keeper, to explain why those records are no longer available, to explain that he did in fact give copies of those original records at the very beginning to us, to the defense, to the patient. In that instance where we can show that we have those copies, and we can show that those copies are the same amongst everybody who had them before, now there's still a good likelihood that we can go ahead and introduce the photocopies as if they were originals. The problem is going to be if there are differences between our copy, the patient's copy, Dr. Number 2's copy, the defense lawyer's copy. And if everybody's got a different set of documents, now we've got problems. So why do I share this great information with you? I share it with you because it's a beautiful day today here in Great Neck, and I wanted to get out this information because this does come up occasionally, where a doctor's office turns around and says, I'm sorry, we can't find the original records. And now, what do? Well, now you have an insight into exactly what happens when that occurs. You know, I do realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but are thinking about bringing a case and still have questions that need answers, what I invite you to do is pick up the phone and call me. You know I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day. Bye-bye, everybody.